a very controversial subject throughout the drafting of this ordinance was how to handle political signs. And most of the research that I did would indicate that regulating political signs and the duration of political signs is a clear restriction on free speech. Fortunately, it was brought to my attention, I think Mayor maybe were the one that did so, with respect to the provisions of Florida Statute 106.143, which did have a particular time limitation for political signs. First of all, I'm not here to defend the state of Florida as to whether or not even that provision is constitutional, but we can certainly rely on it as in our definition of abandoned sign, which we've put into this ordinance. But when you read that statute, the black letter of the statute, the plain language of the statute, is directed towards the candidates themselves with respect to their responsibility for having the signs removed, whether they're defeated, elected, or withdrawn. And so, to the extent that it gives us at least a little additional limited ability to remove signs after an election, we can only do so upon proof that the sign was placed by the candidate and not placed by the property owner who may be supporting the candidate. It's not much, but it's more than what we had. Anything else, I think, would be worrisome. But
respectfully, I have to disagree with you on this one.
No, and that's fine. And so if you direct that the ordinance be modified, that's fine.
To be picky about this, but I saw all these things that in my mind I'm thinking, okay, that's a violation, that's a violation, that's a violation, you know, according to the new terms of the new sign code. And I just don't want us to be the sign police, and I don't want us to be misconstrued as we're trying to enforce something that is not in our purview. I think the idea is to be compliant with the Supreme Court ruling. I understand that. I just want to be reasonable about how we enforce it.
And Nicole, you know, it's really amazing that an ordinance that is being crafted to provide for freedom of speech seems like it's really limiting, people perceive it to be limiting free speech. Every single letter of ire that I've received in the last 2 weeks has been because we are limiting free speech. And if the whole purpose of this is to not limit free speech, we have not sold this very well, I guess. I don't, you know, I mean,
well, I agree totally, but it's us that put all those things in there, wanted David to put them in there.
I know.
Well, yes.
So we've done it to ourselves, and so.
In this particular case, I'm not sure that something that we have seen recently will ever be that acceptable. And we're trying to make the best decisions to provide for flexibility at the same time as help our, you know, somebody who also complained about the fact that you're restricting our free speech, then in the same token, same email complained about our woke police department that isn't able to, can't go arrest somebody who has a sign, is waving some kind of a sign that has bad language on it. And it's like, well, wait a minute, you can't complain about you're limiting my free speech because the police department can't go do anything. It's not against an ordinance, it's not against anything. So until such time that we enact something to make it such that you can. So I think it's, you know, we are in a very difficult situation. I get that. And that's why we're here.
I think we're going to see very quickly what the holes in this are.
Yes, we are. One question, so I have a question. Over the weekend, there was an individual who was at the corner of Taylor and Marion who had something printed on their T-shirt. I have the picture that was forwarded to me by a resident you can't read what was on the T-shirt, and the person's holding a sign, but you can't read because the sign is facing the opposite direction. But they had, the person had a PVC pipe device that they had created, and then they had a big flag with a foul language on it, obscene, about our current president, hanging from it, and that you could clearly read, and it was right there by the seafood festival. I'm sure people visiting our community are thinking like, what in the world? But you could see so we know that, I knew that where it was, but the question is really, we've addressed printed signs on T-shirts or whatever, handheld signs, but what about this PVC thing that's, he's, hanging an obscene sign? I'm looking through our code to say, have we accommodated that?
Yes.
Accoutrements. We use
Yes.
the term accoutrements.
Accoutrements?
Or thing,
What?
or thing. Under our definition of, we attempted to define sign in our definitions
Okay.
to it. We may have overlooked anything, but,
I just want to make sure
but
that that's not a loophole, that's all.
we have attempted to address.
We included the words
Conceivable-
apparel and accoutrements now.
We added that, but we also, we had a discussion, I don't think that was even necessary, but we did it just to be a clarification based on previous discussion of the council. But our definition of sign includes thing. And if that thing displays language which is indecent, as we've defined it, and is legible to people within a public right-of-way, that would include the potential of someone under the age of 17 viewing it, that would be a prohibited sign.
Okay, I just wanted to make sure that wasn't,
We tried.
Yeah, I
And-
saw that it had been added, that it said apparel and accoutrements, so I think that would cover it, if I understand it correctly. Oh, John, I'm
Maybe
sorry.
one final comment. I discussed this, had my personal lawyer read this, my wife, and she's very concerned about the First Amendment issues. And there most likely will be challenges to that. So I want to make sure we understand that. I think what Michael Hurst said is very appropriate, and it's a tough situation when we get into those issues.
Let me address Mr. Hirsch's comments. He cited two cases. The one that he was, that used the F word was a U.S. Supreme Court decision that addressed, among other things, the definition of fighting words. I disagree with Mr. Hirsch's interpretation that the expression has to be immediately in the presence of the person who it was directed towards, and therefore signs can be appropriate. But as we've defined the fighting words definition in our ordinance, it is consistent with the U.S. Supreme Court's decision in Cohen versus California, where the court said fighting words, those personally abusive epithets which, when addressed to the ordinary citizen, are, as a matter of common knowledge, inherently likely to provoke violent reaction. In the Cohen case that Mr. Hirsch cited, the court found that the T-shirt that Cohen was wearing wasn't addressed to anybody in particular, and therefore it wasn't considered to be fighting words. As our definition is consistent with the court's definition of fighting words, it is going to have a very limited application in our city. For example, if somebody put up a sign saying that if you voted for Trump, you're an idiot, some people might consider that to be offensive to them or fighting words, but because it wasn't immediately addressed to a particular individual, but to a group of individuals, the court would not consider that to be fighting words. However, if the sign said, Mr. Smith, you're an idiot for voting for Biden, theoretically, that could be considered to be fighting words. We will probably not be enforcing, to any great extent, signs under the fighting words provision, because it is a very difficult definition to understand, as the courts have provided it to us. But there may be an appropriate circumstance where it will be a tool that we can utilize in that appropriate circumstance to enforce that sign. The U.S. Supreme Court has clearly said consistently that First Amendment rights are not absolute. We have tried to accommodate that consideration in our ordinance. And to the extent that someone may be using indecent language on a sign in a city right-of-way or public place that could be viewed by children under the age of 17, that is consistent with the court's recognition of the fact that free speech is not absolute, and we will enforce those types of violations of our sign code. Hopefully it will be very minimal. Will there be challenges? Who knows? Anyone can challenge any ordinance that we write. The question would be, what is our likelihood of being able to defend our ordinance? Our ordinance is based on the law as it exists today. That may not be the law as it exists tomorrow, but as today, I feel comfortable that the ordinance is consistent with the parameters set forth by the U.S. Supreme Court.
This is a judicial, quasi-judicial board that makes decisions, final decisions on people's futures and the repercussions that go with them. These people on this particular board need to understand that they represent the city when they are sitting at this dais. They represent the rules that the city has in place. They are there to enforce them. They are there to not express personal opinions, not to do name-calling, not to speak to the media before a quasi-judicial hearing takes place. One of the members actually went on record and was quoted in a New York Times article a couple of days before the meeting, which is against all the rules that we live by. If we ever did that, we'd be thrown under the Ethics Commission at the state level and be fired from our jobs and fined and maybe even go to jail.